to discharge, because when we're talking about water pollution, we're always talking about discharges. You can see this is a very broad definition, especially the part that says allowed to seep. Well, if you're allowing something to seep, that is an ongoing violation. In other words, you've introduced some waste or pollutant into or adjacent to water in the state, and you've left it there, which means that every day that it stays there, and it migrates or it seeps into groundwater or moves, that's a separate day of violation. Each day is a separate discharge. And it indicates, if you allow, permit, or suffer any of these acts or omissions. So you can be charged with an omission for failure to act, having knowledge of waste or pollutants on your property or another site maybe where you're working and you don't do anything about it. In other words, let's say you had an accidental spill. You know about the spill and you're thinking we're going to get around to this eventually, but you don't. And it's discovered by law enforcement. The fact that you didn't do anything about the spill once you discovered it is a violation and also constitutes a discharge. Okay. Here are the criminal offenses. They're in 7.145 of the Water Code, and that one is titled intentional or knowing unauthorized discharge. And I've set out the elements here. The elements are what the state has to prove if we go to trial before a judge or a jury. We have to prove, first of all, a person intentionally or knowingly, but only with respect to their conduct, discharges or allows the discharge of any waste or pollutant into or adjacent to any water in the state that causes or just threatens to cause water pollution, unless that discharge is in strict compliance with a permit order issued or a rule adopted by the appropriate regulatory agency. Well, the appropriate regulatory agency is the Texas Commission on Environmental Quality. If it's a discharge into a sanitary sewer, it may be the municipality or mud district or whoever that regulates that sanitary sewer as the appropriate regulatory agency. So the law criminalizes unauthorized discharges, which is probably 98% of all the cases that I prosecute. The other 2% may be permitted discharges, but they're in violation of the permit, and we prosecute those on occasion. But first of all, what do we mean by a person? Most people, obviously, all the individuals in this room are persons, but under the law, a person also means corporations, partnerships, business entities, limited liability corporations, limited partnerships, any type of legal entity that consists of more than one person. We can prosecute as a person. If it's a sole proprietorship, we prosecute the individual that's the sole proprietor and not the business entity, because it has to be at least 2 or more persons to constitute an association or a partnership. Probably at least half of all the cases that we prosecute for environmental offenses are against legal entities and not just individuals. Intentional or knowing with respect to conduct means that it's not a result-oriented offense. In other words, I don't have to prove that the person that I'm charging intended to cause pollution, intended to pollute that body of water. I only have to show that they intended the discharge or knew about the discharge and didn't take care of it, and that discharge ultimately caused or threatened to cause pollution. Into or adjacent to water in the state. Adjacent to is not defined in the statute, but if you go to Webster's dictionary, it just means close to or nearby. How close is close to or nearby is generally an issue of fact for a jury to determine, but we usually have a pretty good idea of what we think that is when we file a charge. And then, of course, that causes or threatens to cause water pollution. Obviously, if you have a discharge into water, it's pretty easy to show water pollution if you have oil that's been discharged into water, for example. Or if it doesn't quite make it into water, but if left unattended, it will, then you have the threat to cause water pollution from that discharge. But 7 is the important one, because if you have authorization, if you come within titled Unauthorized Discharge is Prohibited. This is generally the section that we look at to see if we have a point source violation. And basically, here's how the legislature has defined point source. Any discernible, confined, and discrete conveyance, including but not limited to a pipe, a ditch, the Watts case where he had dug little channels from each voltage into the ditch. Those were point sources. Any container, like a 55-gallon drum that's discharging its waste, that's a point source. Rolling stock, anything from which pollutants or waste are or may be discharged into or adjacent to water in the state. We've used a facility as a point source because we can identify where it's coming from as opposed to non-point source discharges. Boats, rail cars, any kind of container that we can clearly show this is where the discharge is occurring can be a point source. Okay, what's the penalty range? For an individual, it's a fine of not less than $1,000 or more than $100,000. Confinement in prison not to exceed 5 years. So these are felony violations, or both fine and confinement. For other than an individual, say a corporation, corporations can only be fined unless we charge the individuals associated with that corporation. It's a fine of not less than $1,000 or more than $250,000, and that's for each day of violation. And of course, these are felony violations as well. There is an enhancement provision that just basically says if you've been convicted under 7.145 before, the second time, if you're charged again, everything is doubled. So you'd be looking at up to $500,000 and up to 10 years in prison for a second offender. 7.147 is a strict liability offense. In other words, it means that I don't have to prove that you intentionally discharged anything. I don't have to prove that you knowingly discharged anything. I only have to prove that a discharge occurred and you're responsible for it. It's titled Unauthorized Discharge, and here are the elements. Clearly you can see that there's no culpable mental state. That is required. But what do you see that's different between this and the intentional or knowing violation other than the culpable mental state? You notice anything different about this statute? Anybody? If you look at number 4, basically because we do not have to prove a culpable mental state, we have to prove in that instance that the discharge actually made it into water in the state. So the legislature is saying, look, we're going to give you the strict liability offense where you do not have to prove a culpable mental state, but because we're doing that, you're going to have to prove that the discharge in that case actually made it into water in the state. Keeping in mind that we would only have to prove that it went into a storm sewer, into a drainage ditch, into some body of water, whether it's dry or not, because it's a water course, not necessarily that it went into the bayou, went into the lake, or whatever, but just into a water course. Now, because